Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm looking at your comments here. Sorry I'm late, but no, the filing did not break my computer. It just broke my brain. So we're fine. It's actually multiple documents in one single filing. And yes, you read that correctly. It is 802 pages filed just before midnight Eastern time. So this, I'm not going to say a bad word in the first minute of my stream. This horrible person, which I think you all know what I want to say, decided to drop that on me at the, the infinite hour. Just kidding. I know everything's not about me, but still, it's kind of funny that it happened that way. The thing is, I want to say a lot of this, maybe even half of it, is exhibits, which are, pages from filings we've already seen in other cases that they're referencing, but a lot of it isn't. So we're going to go through that together. I'm going to show you guys my whole process. We are not going to read 802 pages word for word. If it was all new information, you better believe I would sit here and do that, but it's not. So we don't have to do that. And then, as always, I've now started doing a shorter series where in the morning I'll post like a shorter recap of all the stuff we talk about tonight. But when I do these things live, it's like right as the document comes out, and I'm walking you through my process of how I get used to these things so quickly, how I get this information, how we go through it, and that kind of stuff. And then usually I have some friends with me, and we're joking back and forth. But unfortunately, because it's so late tonight, it's just me. It's just me and all of you. So hopefully you guys will enjoy this one. And if not, don't tell me about it. I don't want to know. All right. So this is Blake Lively. So she filed last week a motion for like an extension on the page limitations of her response to Jed Wallace's filing in Texas. Now, remember, that was initially due last month. They gave her an extension until today, or technically yesterday, I guess. But yeah. Hi, Zach. I always love seeing Zach. He's great. But yeah, so they gave her an extension until April 4th. And so she files it right before midnight on April 4th. And let me just show you what I'm working with here. And the reason I haven't posted the documents yet is because I'm going to have to combine them all into one file. So here is to get these documents. One sec. Let me move my head real quick. That would probably help. Nope, that's not what I want. There we go. Okay. So you can see here, and I can zoom in a little bit if you need me to, but 17, unopposed motion for leave to exceed page limitations by Blake Lively. And the reason that these aren't up on Court Listener yet, I think, is probably because there are 19 different documents within this single filing, as you can see down here at the bottom. Give me one sec. Okay, so unopposed motion for leave to exceed page limitation. You can see here on number 16 on the docket, there was an unopposed motion for leave to exceed page limitations filed on March 27th. And that's something that, like, the other side was like, okay, that's fine, whatever. And the judge could have signed off on that and been like, yes, that's fine. Unfortunately, there was a deficiency notice because they did not, in fact, include all of the documentation they needed to do that. So I've never seen anything like this before. As you guys know, I'm not a lawyer. That's why it's the Court of Random Opinion. I'm just a rando like you. But this is something the lawyers will have to answer for us later on as to, like, is it okay to, like, file a motion to exceed the page limitation at the final hour? Or do you have to do that ahead of time? I don't know. Because they tried to do it ahead of time, but failed because they didn't include everything they were supposed to. They would have had to include the proposed document, which is what we'll see tonight. Okay, so there's lots of stuff. Oh, Donna, sorry. I keep doing that by accident. I'm so sorry. I know your name is Donna, but because people keep getting it wrong, I'm like, no, it's Donna. It's Donna. It's Donna. And then they're like, no, Dana. So I started saying Diana just to throw people off. Hi, Donna. Thank you for popping in. But yeah, so I'm going to skim over a lot of the irrelevant stuff. I'll show you exactly what we're going to go through tonight. Let me zoom in a little bit more so you guys can see this a little bit better. And also, I just wanted to promote my review of Blake Lively's hair care line. I told you guys if I got enough super chats that one night that I was going to do a review of it. and I did. So let's look at that together so you all know I'm a woman of my word, if not anything else. So here we go. Hang on. Oh, no, that's it. I don't know if you can hear it. Can you hear it? No? Let's start over.
I love you.
As promised, I'm going to try Blake Lively's hair care line so you don't have to. Oh my god! I don't have lesbian pattern baldness anymore! This is incredible! I tried to look at what's in it, but the back of the bottle just said, attorney's eyes only. Smells like donuts. This was obviously a parody. Please don't sue me. Anyways, moving on. Thank you everyone for making that possible. What we have here in the table of contents, I'm going to show you the table of contents. Amended complaint, Lively v. Wayfarer Studios. So we're not going to go through all that. That's Exhibit A, and that's a huge chunk of these 802 pages. Then we have Exhibit B, Affidavit of Kelly Mursky, Process Server. We have Exhibit C, Affidavit of Eric Camp, Process Server. Exhibit D, Articles of Incorporation of Street Relations. Exhibit E, Certificate of Conversion of a Foreign Entity Converting to a Texas Filing Entity, which is a bunch of shit. I don't even know what that means. Because I'm going to be honest, if I don't know something, I don't know something. And guys, I have no fucking clue what that means. All right. Exhibit G, Megan Toohey, Mike McIntyre, and Julie Tate, we can bury anyone inside a Hollywood smear machine. I do know what that means. It means New York Times, your writers are a bunch of cunts. Anyways, Exhibit H, original complaint, New York litigation, December 31st. Exhibit I, complaint, Wayfarer Studios. And I think we have seen this one, yes. If not, we'll skim through it. It was the California complaint against the New York Times, which eventually was dropped because they moved it to New York court, which the judge has not yet ruled on the New York Times motion to dismiss, even though it has been fully briefed. Okay, Exhibit J, January 23rd to 28th, emails from Brian Friedman concerning service of process on Jed Wallace. That is something I'm looking forward to reading. Transcript of initial pretrial hearing, New York litigation is Exhibit K. We have Exhibit L, petitioner's notice of non-suit without prejudice. Exhibit M, declaration of Jed Wallace, which I believe we read in his response to the, or not the response, but his motion to dismiss Lively's New York lawsuit. Exhibit N, memorandum of law in support of defendant's motion to dismiss, or in the alternative, motion to sever and transfer venue, New York litigation. So that I'm probably going to read, all the way through. I'm not sure though. Exhibit O and Exhibit O1, they're declarations of Laura Lee Prather and also the legislative history report and analysis for the Assembly Bill. If you guys are super interested in the Assembly Bill, that's like a 200-page document, that one. So I will pull it up and I will post it for you guys to go through, but we're probably not going to go through that one tonight, just because I honestly don't think I really have much insight into legal analysis of Assembly Bill 933. I'm just kind of a random person, so I can't help you with that, but I will post it for you if that helps. So, all right, we'll see. Wonder if Judge Lounge is watching. It is in bed watching. I hope the judge isn't in bed watching. I mean, that'd be bad. YLM says, I keep getting unsubscribed from you. Anyways, just wanted to say you were the medium now. Thank you for stepping up and reporting the truth. Yeah, YouTube keeps doing this weird shit where I get unsubscribed to people too. So it's not just you. There's a bunch of us. So yeah. But yeah. Anyways. Does the judge really read all this? Well, this is a judge in Texas, mind you. So this is not Judge Lyman. This is not the New York judge at all. That's why it gets so confusing, because it's like, Lauren, didn't you just go through the response to the motion to dismiss 2 days ago? The answer is yes, but that was in the New York court. And this is in the Texas court, which is probably why it came out so late at night. They were crunching the deadline, and they got it in at like 10 p.m. their time, 9 p.m. or whatever. But the thing is, I live stream hopping all my favorite YouTubers tonight, but I hope Lauren wins. I don't know what winning means. I'm just going to be here anyways because I want to go over this stuff. I'm also just super interested in this stuff like you guys are. So, anyways, well, let's see. We'll go through this stuff. Anyways, if she's trying to say, basically, the Texas lawsuit that Jed Wallace filed should be moved to New York, and he's saying, No, we had first filing here in Texas. And the thing is, she actually tried to depose him in Texas, like she filed in Texas court before she ever tried to sue him in New York. So she did not name Jed Wallace and his company Street Relations Incorporated in her like first complaint. She didn't do that. And in the amended complaint after Jed Wallace filed this lawsuit in Texas, she then named him in the New York case saying, oh no, it belongs here. Like, no, there's a reason you left him out the first time. You don't just accidentally forget to name the invisible smear campaign conspirator in your lawsuit. That's not a thing. So there's a reason she left him out, and it's because she knows, in my opinion, that she did not have a case against him. Even if he is some sort of smear master, there's a reason she left him out. And it's because it looks bad for her. So hopefully we'll find out why that is eventually. All right. Okay. I looked up Melanie King off script today, and it said there was no channel by that name. I saw Melanie off script today, I think. Didn't I? I hope I'm not making that up. Okay. So they came back with another motion to dismiss. Probably thought the first one was not good enough. No. Different states, different cases. So Jed filed this in Texas, so she has to file a motion to dismiss his lawsuit. Okay. GGH, thank you for the $5 for your Friday fun fund. Thanks for all your hard work. Thank you, GG. I appreciate it. This is the fun for me. I'm too old to do anything else on Friday nights now. All right, so here is the initial filing we got here. And I don't know if you guys saw, if I showed you. This is the whole, every part of this filing is right here in this Dropbox, which I'm going to post later once I combine the files. But there are at least 17. There's 18 here. Yeah, 18 different documents. 19 different documents. And that's why it took me so long to start this stream, because it's like nutty over here. But we at least have the table of contents, I guess. I mean, my God. This is throwing me off a little bit. I'm not used to seeing anything like this. I've never seen anything this long before in court filings, but I've only covered a couple of court cases. You guys know that, so. All right. Let's share this tab instead. Oh, you couldn't see that, could you? Fuck. My bad. Let me show you real quick. I just pulled an Omar, didn't I? I just pulled an Omar. That was terrible. All right. Here. Anyways, that is the list of documents. You can see there are 19 documents here, 17 dash blah, 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 blah. There's 19 of them, technically 20 because the first one isn't just named 17. And here's what we're going to look at first. This is defendant's motion to dismiss for lack of personal jurisdiction, improper venue, and failure to state a claim. And remember the other night, the motion to dismiss was pretty, it was pretty dumb. Hang on. Or the response to Jed's motion to dismiss was pretty dumb. And that's why I was saying, like, I don't know if I'm dumb or if this filing is dumb. But somebody's dumb because this is not making any sense. Apparently it was not me this time. It was dumb. But anyways, we're going to skim through this because, guys, we're not trying to read through 802 pages or however many hundreds of pages there are. It is almost 1 o'clock in the morning here, so. All right. Oh, my Lord. Cite some more, why don't you? God, this is like a bad term paper. Oh, Jesus. Okay. All right. Defendant Blake files this motion to dismiss plaintiff's complaint for declaratory judgment and defamation pursuant to Rule 12b-2. Introduction and summary of argument. This case is a sham. You fucking bitch. This case, sorry, I can't even say that with a straight face. This case is a sham designed. It's as much a sham as your fucking hair care line. This case is a sham designed solely to harass and retaliate against Blake Lively for exercising her right to seek legal redress for workplace sexual harassment and retaliation. In December 2024, Ms. Lively filed an administrative complaint with the California Civil Rights Department, which alleges inter alia that plaintiff Jed Wallace, by and through his company Street Relations, aided and abetted a malicious social manipulation campaign against Miss Lively designed to harm her reputation and undermine her credibility in retaliation for her raising concerns about sexual harassment and other misconduct on the set of the film. It ends with us. Okay. The allegations in the CRD complaint against plaintiffs are clear, unambiguous. Is that a joke? Wait, why is my phone going off? One sec. Sorry. Are clear, unambiguous, and include extensive and verbatim statements in their conspirators' own words. My lord. Including text and email images. Plaintiffs assert that they were defamed because the caption page of the CRD complaint, which lists all parties on the left side and alleged causes of action on the right side, as is the standard format for cases in California, caused some confusion with the public about who and for what conduct Miss Lively was suing. But plaintiffs' claims, based on this specious theory, fail as a matter of law and require dismissal for multiple independently fatal reasons. Dismissal of the complaint in its entirety with prejudice is first warranted based on incurable procedural grounds. The court cannot, consistent with constitutional due process, you want to talk about constitutional due process now, honey? Okay. And FRCP 12b2, exercise jurisdiction over plaintiff's claims because Miss Lively is not subject to personal jurisdiction in Texas. Then why the fuck did she file a... Never mind. All right. Miss Lively is not subject to personal jurisdiction in Texas. Well, then mark all the Texas donut shops safe, everybody. We're good. Okay. Miss Lively is a resident of New York and has not availed herself of this state, including because she did not target it when she chose to exercise her First Amendment right to initiate the CRD complaint and identify plaintiffs in its caption, which is an administrative prerequisite to filing such employment claims in California. Okay, so I'm not really seeing their point here. Resident of New York, not availed herself of the state, including because she did not target it. No, you targeted an entirely different state that had nothing to do with any of this. You weirdo. That's not helping. All right. Well, moving on, because I can't try to understand every single gibberish that I read. As I've learned in my time as a psychiatric evaluator, some things are just fucking dumb and crazy. Okay, so we're going to move forward. Even if the court has jurisdiction over Miss Lively, the first to file rule requires the court to decline to exercise jurisdiction over plaintiff's claims because they substantially, if not entirely, overlap with pre-existing litigation that Miss Lively initiated in federal court in New York on December 31st. But babe, you started this in Texas. All right. But please, 802 pages to distract us will help with that fact. Plaintiffs admit they filed this lawsuit in anticipation of and to avoid being named in the New York litigation. That is absolutely not fucking true. What are you talking about? Oh my God. Which occurred when Miss Lively filed an amended complaint in that action on February 18th that named both plaintiffs as defendants. My lord. Let me move the thing so you guys can see it better. My bad. And a fan says some things are just dumb and crazy. Everyone with a crazy ex. Yeah, I feel like we all have a crazy ex at some point, right? Even our crazy exes have crazy exes. It's wild. Let me read through some of your super chats. GGH, I think I read that one. Thank you again, though, GGH. Let's see. CJ, thank you for the $5 for coffee. I actually had a Red Bull before this. Thank you very much. I appreciate you. Rihanna Vasconcelos, I hope I said that right. How many pages, Lauren? This is 802 pages in total, but we're going to go through filing or document, divide document, and then we're going to skip a lot of this shit. So thank you. Thank you very much. I appreciate it. All right, let's see. McHighlife, thank you for the $20. Lauren, I'm new to commenting, but watch often. Thank you for being on top of these docs and sharing them. You're amazing. While I can't stand Blake, I'm grateful that this case brought all of us together. Justice for Justin. I echo that sentiment, and thank you very much for being here. And thank you for commenting, even though some people can't always comment and stuff like that, because sometimes I'll watch YouTube on my TV or something while I'm doing something else in the background or working, and you can't really comment well on that when you're watching on the Xbox or something. So thank you. I see you guys too. I appreciate you. All right, Anna Fan, thank you for the 5. This case is a sham. Let's buy Lauren a coffee and a tax attorney. Thank you very much, Anna. Katie Arsenault, thank you for the 10. For the court document fund, 802 pages from Pacer must cost a pretty penny. Thank you very much. It costs a little bit. It really wasn't that much. I think it was around 28 or 29 bucks. So I don't want to overplay it or anything like that. It was like 30 bucks, but between all of you guys, I'm pretty sure I've made up at least that in the super chats now. So yeah, thank you very much. Basically, you guys helped me pay for the stream. So, all right. Let's get back to the nonsense. Even if the court has jurisdiction over Ms. Lively, the first to file rule requires the court to decline the exercise jurisdiction over plaintiff's claims because they substantially, if not entirely, overlap with pre-existing litigation that Ms. Lively initiated in federal court. Which, again, not true, but, whatever. Plaintiffs admit, and we read that just a couple minutes ago, and I'm still just like, I'm reading it, and I'm like, I'm baffled by how they're wording this, because I'm like, they absolutely did not admit that. In fact, they said it was somehow defamatory that she, put this out in the New York Times and didn't even name them in the lawsuit. It's like, you knew we didn't do what you're accusing us of doing. So, all right. The court should reject plaintiff's blatant forum shopping in an attempt to divest the first filed court in New York of its rightful jurisdiction over the claims. Finally, FRCP 12b3 separately necessitates dismissal because plaintiff admits that a substantial part of the events giving rise to his claims did not occur in this district. Even if arguendo, plaintiffs could overcome the substantial jurisdictional and venue defects, both causes of action should be dismissed under FRCP 12b6 for failure to state a claim upon which relief can be granted. The complaint's first count, which is a claim for declaratory relief, requires dismissal because the law does not recognize such as an independent cause of action. The second count, for defamation, also requires dismissal for multiple independently fatal reasons. Plaintiffs have not and cannot plausibly allege that the inclusions of their names in its caption, standing alone, gives rise to a defamation by implication claim. Nor have plaintiffs properly pleaded that Ms. Lively made these statements contained in the CRD complaint with actual malice or negligence, or that Ms. Lively, as opposed to plaintiff's own conduct, directly caused the millions in damages sought. Moreover, Moreover, the CRD complaint cannot serve as the basis of a defamation claim because it is a legal pleading protected by multiple privileges, including the litigation, fair report, and sexual harassment privileges. The court should thus dismiss plaintiff's meritless claims with prejudice. And I kind of said similar stuff to this before, right? But I'm just going to say this outright tonight. As somebody who's been through, unfortunately, abuse in multiple relationships, when you're young, like a teenager, and it gets ingrained in you young, not from my family at all. My family's great. But just from other influential figures in your life who are, they have a position of power over you, they have influence over you, and they hold an important place in your life. It's very scary to grow into who I am now and just know people are not going to believe me, because if I say all of this stuff happened between when I was 16 or 17 and now, it's going to sound crazy. It's going to sound crazy if I tell everyone everything that happened to me, and if I come forward and I say all that, or if I ever tried to get justice for what I went through, it's going to sound nuts. And the reason I think it's going to sound nuts, the reason I don't even try, is because of Blake Lively. Women like Blake Lively. Women like Amber Heard, who do shit like this. So when it comes to the sexual harassment privileges, I don't support whatever exploitation of this law they're trying to use. That actively hurts me, and I'm not some entitled thunder cunt abusing the system to hurt a man who has done nothing but try to uplift women and victims and support our equal rights and our equal standing in society and try to build healthier relationships and build deeper relationships and supported nothing to the contrary. I'm not okay with her exploiting this law meant to protect normal people like me. Well, not like normal mentally. I'm obviously kind of a weirdo, but like normal as in like I'm not a rich, powerful Hollywood person. This person is exploiting normal people like me and my experience and the things that I'm afraid to talk about and everything that I've been through and afraid to be like, nobody's going to believe me that I went through all this stuff. She's exploiting that to try to get more power, to try to get more attention, to try to become a even higher regarded figure and to like have all this power and just take over stuff and like punish people who have done nothing but actually try to help the little guy. And I say guy obviously colloquially, the little guy like me. So I am offended by this and every other filing that this again thunder cunt has made, because I'm like, dude, every time, every day that you go forward with this and don't apologize and say I should have stepped back and thought about things, or even if she has like a troubled past with the way that she went through Hollywood and what she had to do to get where she is today, even then saying I am sorry and I need to have some self-reflection and realize that I kind of took things out in the wrong way and I shouldn't have done this, even that would like help, right? But she's not doing that. She's doing the opposite. And that's somebody that I, as somebody who, I'm not like a group attention person. I hate group attention. I like playing puzzles with my family. I like, going to football games sometimes with some friends, but like, I'm not a very social person. And so I don't like to be in front of people and say all this stuff, but that's what made somebody like me stand up, or technically I'm sitting in a chair, and be like, no, this is too far. No, you need to sit down. Stop. This is wrong. I'm not okay with this. So hopefully that made sense. But anyways, when I read stuff like this, it makes me very angry and it makes me want to go off on tangents like that. So anyways, fuck you, Blake. All right. Factual background, which is hopefully going to get me back on track here. Wallace is a hired gun who specializes in launching oh my God, I've heard this 1,000 times and you're still stupid. Wallace is a consultant and owner of Stret, which provides crisis mitigation services to high-profile clients. Okay. Good story, bro. Wait, did they just repeat that? No. Okay. I'm thinking about the other filing. Never mind. Okay. He has a proprietary formula for defining artisan trends. He claims to help his clients navigate real-life human crisis and threats, among other things. Wallace specializes in confidential and untraceable campaigns across various social media platforms to shape public perception of his clients and their adversaries. And I've heard all this bullshit before, so I'm going to skim over some of this. All right, so they're talking about jurisdiction here, which is like not something I really care about because, to be honest, I and most people who have been through actual sexual harassment, abuse, assault, whatever, we look at your jurisdictional issues in the court and what you're doing and all the shitty technical legal filings you're putting forth, and I think you're full of shit. So I don't really care to read word for word what's going on here, but I'm going to skim through it. This stuff just doesn't matter to me. The fact of the matter that is actually important to me is you lied. There's proof of it. And now, I don't know. I just wish this never happened to these really good men who, even if they made mistakes in the past, are open about it. I hate that. They didn't do anything to hurt anybody in the past. And they're open about it. And they're saying, this is how I grew. This is what I learned. And you're punishing those guys. You're punishing that man, the man who sat there with his wife while she told him even her father wasn't a safe man for her to be around, but he is the first really safe male space for her to be in. You picked that guy to go after. So anything they write here is not going to matter to me. All right. She's an actress and entrepreneur. Entrepreneur is a funny stretch. Who resides in New York. She starred in the hit film It Ends With Us, which Justin Baldoni directed, and his movie studio Wayfarer Studios produced and owns. Cool. All right. Notwithstanding that Baldoni was Miss Lively's boss, the CRD complaint alleges that he and Wayfarer's chief executive officer, Jamie Heath, subjected Miss Lively and others on set to a pattern of unprofessional and sexually harassing behavior. I've heard that lie before, so I'm going to skim past that. Okay. And I don't give a shit about who played the OBGYN. Not sure what this has to do with Jed Wallace and the state of Texas, but, you know, cling to whatever you can, I guess. Jesus. All right. In the summer of 2024, Baldoni became concerned that Miss Lively would speak publicly about the hostile environment she and others faced on set. Okay, so I would say, and I would characterize this differently, Baldoni became concerned that Miss Lively would act on her previous threats to fuck shit up for no reason, and hurt the movie's publicity and all that, and hurt his reputation, his career, his family, and his livelihood. So, all right. They're talking more about the social crisis team. And this is where I'm really going to start to skim through a lot, guys. April Love, thank you for the one gifted membership. I appreciate you. Just Ricardo, thank you for the $2. 802 fucking pages. I'm not going to read that ish. It's actually a different judge, because it's a judge in Texas who has to read this. She had to file a response to his motion, to his lawsuit in Texas. The judge, Judge Lyman in New York, will decide like, oh, this makes sense for Texas or this makes sense for New York. But ultimately, she did have to file a response to this because Jed Wallace in Texas was the one who initiated this. And if Jed Wallace, prevails in this, getting it in Texas, I'm going to go to Texas and I'm going to watch this lawsuit. And I intend to also go to New York to watch the other lawsuit between Baldoni and the rest of them, which hopefully Jed gets dismissed from that, but we'll see. All right. Oh, this is to Jed Wallace. Yes, this is so Jed Wallace filed that lawsuit in Texas, and now she's trying to get it dismissed. How many pages is the actual filing? Well, the filing consists of 19 different documents, so it's 802 pages. But like I said, I'll combine them and I'll post the relevant stuff later. So let me get moving on to skimming through some of this stuff because it's almost 1 o'clock in the morning, and I'm going to do a short recap of all this tomorrow in the morning. I promise. But thank you for listening to me drone on. I appreciate it. Anyways. Okay. Initially, Baldoni expressed concerns that Tag's written plan was insufficiently aggressive, and I've seen you bullshit about that before, so I'm going to skim through that. Hold on. A few days later, Baldoni set the tone for the social combat he and his co-conspirators would enact, sending Abel a thread on X that had accused another female celebrity of bullying women. Baldoni stated this is what we would need. We've seen that before. But I'm going to encourage all of my followers who are watching this right now. If you follow me on X, it's Lethal Lauren 904. If you follow me on X, go and leave a nice message about Justin. Go leave a nice message about Jamie, about Wayfarer, about Steve, about all of them. I don't want this to be just about Justin, even though obviously Justin is the one who kind of gripped my emotions in this. Jamie Heath is also a very good man. I don't know much about Steve, but he seems like a good guy. And then Wayfarer as a whole, I'm going to watch their new movie this weekend, so that'll be cool. But go to X, go to Instagram, go to wherever, and just leave them a positive comment. Because what they would want people to do in response to shit like this is to bring more positivity, right? Because that's just who they are. Like, they're better people than a lot of like a lot of people that I know. So they're better people than me, honestly. I say rude or bad words, and I lash out sometimes when I get emotional, and I think that applies to a lot of us. But those guys they're really doing their best not to say anything negative about anybody. I have never heard any of them say a bad word about anyone else involved in this, and that's saying something. Even when the lawyers get involved, it's like that didn't come from Justin, that didn't come from Jamie. That's their Baha'i and their faith, which I'm still learning a lot about, precludes them from doing that. So I don't think that they would. All right. Shortly thereafter, when the press and public were beginning to notice that some of Baldoni's fellow cast had unfollowed him on social media and were not appearing with him, the Wayfarer parties brought plaintiffs into their conspiracy. Yeah, fuck off. All right. I'm going to skim through this. If we see anything new, then I'll cover it. But on August 10th, TAG expressly acknowledged the success of plaintiffs' effort to shift public attention from stories about Baldoni's misconduct into a manufactured and harmful narrative about Miss Lively, stating they had started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Okay. Again, I've said a million times, looking at that message, it's like you could be referring to fucking anything. There's a million possibilities for that. So I'm not going to sit here and be like, oh, yeah, that's totally damning. You know what I mean? Okay. In December 2024, Ms. Lively filed the CRD complaint and the New York litigation based on the same claims of sexual harassment and retaliation. The same false claims, I might add. Okay. Defendant's motion to dismiss. On December 20th, and as a prerequisite to filing a lawsuit in federal court, Ms. Lively filed the CRD complaint, which included a required intake form. Congratulations, you lied on your intake form. What the fuck do you want me to say to that? The CRD form identifies 10 respondents, including Wallace and Stret, and states as follows. Okay. Additional complaint details. Complainant Blake Lively alleges that respondents Wayfarer, Justin, Jamie, Steve, Melissa, the agency group, Jennifer, RWA. Who the hell is RWA? I'm sorry. Jed Wallace and or Street Relations engaged in a variety of conduct in violations of the California Government Code Section 12940, the FAEJ, and Title VII of the Civil Rights Act of 1964. Oh my God. The conduct includes sexual harassment, retaliation, failure to investigate, prevent, and or remedy harassment, and aiding and abetting harassment and retaliation. Please see attached complaint for specific details. Okay, well, anyone can say that shit in a court document. It doesn't mean it actually happened. So, I would like to file with the court as well. My name is Lauren. I tried Blake Lively's hair care products, Blake Brown, and now I look like a lesbian gym teacher. Okay? So, like I said, anyone can just make shit up. If we're playing with fiction here, that's fine. You can write a book like Colleen Hoover did. But if you want to play with court filings, maybe up your game a little bit. Jesus. Okay. CRD complaint identified the same individuals in its caption and sets forth specific factual allegations. Okay, except you didn't identify Jed Wallace, who you're being sued by in Texas. Get a life. All right. In response to the CRD complaint, CRD issued a right to sue notice, which allowed Ms. Lively to pursue a lawsuit for up to 1 year. Sorry, I'm reading that. And I'm very confused by what happened next, because on December 20th, Ms. Lively's counsel sent a copy of the CRD form and CRD complaint and a cease and desist letter to Wallace, which was shared with attorney Brian Friedman, counsel for Baldoni and Wallace. The next day, several press outlets reported on the CRD complaint, but leading the race was TMZ, which included a defamatory statement from Friedman on behalf of plaintiffs, among others. You want to talk about defamatory statements? For real? Okay. Later that day, the New York Times published an article reporting on the allegations of the CRD complaint entitled "We Can Bury Anyone." We're saying that passively here. Like, later that day, the New York Times, they put out this article. No, bitch, you fed them that article. They ate it up because you're a Hollywood elite. And they didn't give a shit about the other people involved. They gave them what? Maybe 12 hours to respond. And even if it was a little more than 12 hours, it was way less than 24 on a holiday weekend before Christmas in weird ass time in California. So maybe don't put that in your filing because now you look even more like a cunt. Okay, moving on. On December 31st, she filed a complaint in the U.S. District Court of the Southern District of New York. I noticed she didn't mention here that she failed to name Jed Wallace in that complaint, but okay. Congratulations, you're a dumbass. On January 16th, all of the NY Wayfarer defendants other than Tag filed a separate lawsuit in the first filed court asserting 7 causes of action, including based on the allegation that the CRD complaint was rife with lies and doctored evidence. On January 20th, the first filed court consolidated that case with the one previously filed by Ms. Lively. Okay, so of course they waited. They didn't want this to go to court. Nobody wanted this to go to court. You pulled that trigger. Okay? This was some petty backwater attempt to take over a film, and you couldn't handle your bad press for your bad hair care line and your shitty booze brand. I don't know, man. This is just so entitled. This is so much entitled bullshit, is how I feel about it. D. Wallace evaded and obstructed Miss Lively's persistent efforts to seek information from him before filing this lawsuit in anticipation of becoming a party in the New York litigation. That's interesting. Okay. On January 21st, Ms. Lively initiated Rule 202 petition in Hayes County to obtain a pre-suit deposition of Wallace to investigate the full nature and scope of his role in implementing and carrying out the retaliatory campaign against her. Wallace repeatedly evaded and obstructed Ms. Lively's persistent efforts to serve him by process server and by certified and USPS mail. On January 3rd, after trying to serve Wallace at his gated property, the process server received a text message from an associate at Friedman's law firm stating, "The law firm Liner, Friedman, Tatelman, and Cooley LLP will accept service for him. Do not try to serve him again. Thank you." Sounds pretty standard. All right. Later that day, Friedman claimed that my office never agreed to accept service of process of anything and then denied any such arrangement. I'm going to say there's more to the story than that, but okay. Friedman's emails, Exhibit J is what they're citing here, and we're going to look at that because I have those too. Wallace's counsel also indicated that Wallace had suffered a life-threatening heart incident because of the stress caused by attempts to serve the Rule 202 petition. Ultimately, Miss Lively did not serve Wallace. Sounds like a whole lot of your fucking problem, but okay. On January 31st, the New York Wayfarer defendants, notably without being joined by Wallace or Street, filed an amended complaint in the New York litigation to include the New York Times as a party. How is that relevant? The parties to the California complaint, including Wallace and Street, dismissed the California complaint on February 3rd. That same day, during an initial pretrial conference in the New York litigation, Friedman explained why the New York Wayfarer plaintiff chose to file an amended complaint to include the New York Times and to dismiss the California action. Okay. He said, "After seeing your case management order and just for the efficiency of the case, it kind of made no sense to be doing this on different coasts and with different courts. It seemed that so many of the issues are going to be so similar that to have it all in one proceeding in front of your honor would make the most sense." Okay. During the same hearing, counsel for Ms. Lively represented to the first filed court that she would be amending her complaint to add additional parties and claims. Accordingly, including based on Friedman's representations to the first filed court and for judicial economy, the very next morning, Ms. Lively filed a notice of non-suit with prejudice of a Rule 202 petition in favor of adding Wallace and Street to the New York litigation. Okay, and we're going to 16, Exhibit K. which is, I have to reference all this shit, guys. Transcript of initial pretrial hearing, New York litigation, February 3rd. So as you guys know, probably if you're watching my channel, I bought that transcript. Like, the transcript will not be released until May. So I went and I bought it from the court reporter, which anyone can do. It's just expensive. Just because I was like, I want to know what's going on. I want to know exactly what was said and exactly what's, happening here. And Jed Wallace, I don't think Jed Wallace was mentioned by name at any point, but I have posted that freely online for anybody to go and search it if you want. Did they mention Jed Wallace? Because I don't think Jed Wallace was mentioned at all in that hearing. And that, in my opinion, like, why the hell are you trying to make it seem like it was? So that's just me. Drunkest Turtle, thank you for the $8. You thought you were using Blake's shampoo, but it was actually a real boo. No sham. Thank you to my friend Drunkest Turtle there. I'll be hopefully seeing them again in Australia in a little over a month. Yeah, well, 2 months, kind of. All right. Okay. Let's see. This is all pretty repetitive. 18th. I really want to skim over a lot of the repetitive stuff here, so I'm going to start skimming some more because we have a lot to go through. So, okay. That's argument. Plaintiff's claims require dismissal as a matter of procedural law. That's for the two lawyers, guys. That's not for me. And if they need it, because I don't see it on Court Listener, I can send them this document, but they probably have a Pacer account, so they don't need it. But if they do, just let me know because I will send it to them. We're going to skim over that. Miss Lively is not subject to personal jurisdiction in Texas. Well, Miss Lively is just so special. Anyways, I wonder if she's subject to personal jurisdiction in Texas for the weird stalking shit she did at the hotel recently. Just wondering. Anyways. The Rule 202 petition does not subject Miss Lively to personal jurisdiction in this case. All right. Personal jurisdiction cannot be premised on plaintiff's allegation that Miss Lively aimed statements at Texas or caused harm in Texas. Sure. Let's see. Defendant's motion to dismiss. Again, we have that here. I think that's just the title, but they formatted this shit weird. Okay. It is undisputed that Miss Lively filed the CRD form and complaint with the California Administrative Agency based on violations of California law by her California employers and by their co-conspirators, including by Stret, which was incorporated in California throughout the period relevant to this action. Plaintiffs previously admitted in their suit against the Times that the conduct causing the alleged injury occurred in California. The CRD form and complaint focus on activities that occurred outside of Texas, namely New York, California, and New Jersey, and mentions Texas only in connection with Wallace's domicile here. Yep, that's kind of a big one. Yep, okay. These passing references are a far cry from what's required to show that the jurisdiction is the focal point of a publication. Ugh. Sweetheart, you have to stop. Okay. Plaintiffs suggest that Ms. Lively nevertheless is subject to personal jurisdiction in Texas because the CRD form and complaint undoubtedly caused harm in Texas. Even if the allegation about purported harm were not conclusory, it is jurisdictionally irrelevant because mere injury to a forum resident is not a sufficient connection to the forum. Those are certainly all words. All right, anyways. As such, the Fifth Circuit and this court have repeatedly dismissed cases for lack of personal jurisdiction, even when the plaintiff suffers injury in Texas. Wow, I'm bored. Okay, anyways. More. Can you guys just call each other names? That'd be better for this. Moreover, even if the... I'm just kidding. Moreover, even if the majority of the claimed harm is felt in the forum state, courts have declined to find personal jurisdiction when the statements focus on activities and events outside the forum state. Dismissal is required pursuant to FRCP 12b2 because Texas is not the focal point of either the CRD form and complaint. And I feel like that was obviously a calculated thing, but congrats, I guess. Your hair, Caroline, still sucks. All right. 2, the first to file rule requires dismissal of the complaint in full. Federal courts, including the Fifth Circuit, long have recognized that the principle of comity requires federal district courts, courts of coordinate jurisdiction and equal rank, to exercise care to avoid interference with each other's affairs. That makes sense. Okay. Skimming through the case law. There is no question that substantial overlap exists between this case and the New York litigation. Indeed, plaintiffs have attached to the complaint and based their complaints in this action the CRD form and complaint that Ms. Lively filed in order to receive permission to file the New York litigation. Ms. Lively then initiated the New York litigation by filing a virtually identical complaint. Yeah, but she didn't name Jed Wallace or Street Relations Incorporated in that complaint. Like, sorry, you're a dumbass. Why are you advertising it? Ms. Lively then initiated the New York. Okay, so we got that. Accordingly, both this case and that one will turn entirely on whether the allegations in the CRD complaint are true. Indeed, there is not simply a likelihood of substantial overlap between the two cases. There is actual and substantial overlap, including because they involve closely related questions or common subject matter, share overlapping core issues, and much of the proof adduced would be I don't know if it's adduced or adducted, would be identical. Okay. Right. Let me attempt to argue the first filed case, blah, blah, blah. The court should dismiss this lawsuit based on improper venue. We've seen way more than enough about that, so I'm going to skim through that. Okay. FRCP 12b6 requires dismissal of both counts for failure to state a claim. A lot of this is very similar to the stuff she filed the other night, so I'm not going to read through this too much, guys. We're going to move on to the next stuff. Ms. Lively identified all defendants, including Wallace and Street, opposite a list of the causes of action alleged therein, which is common practice in many jurisdictions and required in California state courts. Congratulations, but you still didn't name him in the lawsuit for a reason. You're a moron. That's probably why it took you until midnight my time to file this on the day it was due. Jesus Christ. You suck. Okay. Anyways. Moreover, the CRD form and complaint do not convey false statements of fact about plaintiffs. Legal filings contain preliminary accusations of wrongdoing, not adjudicated conclusions. It is somebody should tell her that. It is well understood that a complaint includes allegations of wrongful conduct that are tested through the course of litigation until a judge or jury ultimately decides whether the allegations are true. Oh, congratulations, honey. Maybe have your lawyers remember that when they're giving statements next time before they insult survivors of actual sexual harassment and abuse, because I'm fucking pissed. Again, read as a whole, a reasonable reader would not understand the CRD form as asserting or implying false statements of fact about plaintiffs, particularly when the CRD form contains no specific statements about plaintiffs and the CRD complaint contains only limited references to Wallace. Okay, let's see. We'll read that one more time just to make sure I'm understanding. It says it's well understood, so I want it to be well understood. The complaint includes allegations of wrongful conduct, okay, that should be tested through court. Okay. Read as a whole, a reasonable reader would not understand the CRD form as asserting or implying false statements of, well, ma'am, who's going to tell her? Who's going to tell her that's not true? Who's going to tell her she's dumb? Okay. Anyways, I just wanted to make sure that I said what I thought it said. Okay. Because plaintiffs failed to plead the requisite elements of a defamation by implication claim, the claims must be dismissed. Okay. Well, you can dismiss yourself from my life, and then we'll call it even. How about that? 3, plaintiffs failed to plead fault. Plaintiffs cannot survive dismissal because they fail to plead fault, whether in the form of actual malice or even negligence. Again, it bothers me that our legal system is being used this way. I understand that the laws are supposed to be in place to protect like regular people who go through awful shit. But it's being abused now by the Hollywood elite to punish people who are just like a tier lower than them because they didn't get what they wanted. All right. Plaintiff's lone paragraph attempting to show Miss Lovely acted with actual malice does not satisfy actual malice's subjective test. Is that all? Okay. Just checking. There's a lot of parentheses here. As demonstrated by the filing of the amended complaint, Ms. Lively believed when she filed the CRD form and complaint and believes now that plaintiffs engaged... Well, hold on. Believes now. Anyone can pretend to believe something. Anyone can be, like, in denial. Do I think she was delusional? No. I think that she knows deep down that this was her fault, that things didn't go her way because of her actions, and I don't believe she should be able to use mental health as an excuse. I think that's bullshit, and I say that as someone who works in crisis psych. So when people are actually having a crisis where they believe things that are not true, it's my job to make sure they get help. And I'm telling you, everything that I know about this situation, from spending hours and hours reading all these documents, hundreds and hundreds of pages, that's bullshit. I'm not going to say that. She is a bad person. How about that? Okay. Ms. Lively believed when she filed the CRD form and complaint, and believes now the plaintiffs engaged in a retaliatory social media campaign to harm her for speaking out about the sexual harassment in a hostile workplace she endured at the hands of plaintiffs' partners Baldoni, Wayfarer, and Heath. Well, then I'm suing because I, like I said earlier, tried Blake Brown, and now I'm fat. How about that? I believed when I said that out loud that I'm fat because of Blake Brown. Should that be a suable offense? My God, dude. Oh, somebody says you need to wear a Justice for Justin t-shirt. I need to check my mailbox. I was supposed to get a shirt from Zach today. Or maybe yesterday. I'm not sure. I need to check it, but I will. Probably tomorrow morning. Because I'm not going out there tonight. Let's see. It's not in front of my house. There's like a thing in the front of the neighborhood, but plaintiffs failed to adequately allege that they suffered damages attributable to the CRD form and CRD complaint. Finally, plaintiffs failed to sufficiently plead facts supporting their alleged $1 million or more in damages. I think it was $6 million, wasn't it? Get your facts right. When, as here, the allegedly defamatory statements involve a matter of public concern. All right. Plaintiffs do not allege that they have lost jobs, profits, contracts, or suffered any other specific damages because of Ms. Lively. Boilerplate language about damages and recent defamation awards in other cases are off base and irrelevant to this case. Well, wow! Take that and use your thinking cap to apply it to yourself. Your Texas lawyers finally figured out you're a fucking dumbass. Congrats. Okay. Count 2 must be dismissed because the CRD form and CRD complaint constitute protected speech under the California law. Yes. If you're telling the truth, and Blake Lively is not. So we're going to move through that. Like I said, I'm going to do a recap of all this stuff tomorrow, guys, so I will actually go through the whole thing. It's just tonight, the first time I'm seeing this, I'm like, I cannot put you guys through 800 pages of me doing this. So, all right. Here, there can be no question that the litigation privilege attaches. Indeed, plaintiff's entire case is based on Ms. Lively, including their names in the caption of a complaint filed with a government agency. As an administrative prerequisite to initiating litigation. Are you stupid? Like oh my God, you left them out on purpose. So like here, the fact that the claims are identical to the CRD complaint are very important here. But then also later on, they're like, well, you know, just because he was left out of the CRD or he was on the CRD complaint doesn't mean we should have sued him. Fuck off. All right. That's stupid as hell. The fair report bars any claims based on provision of the CRD form and CRD complaint to the media. Let's not talk about fair reporting in this case. Yeah? All right. No, I can already tell this is going to make me so mad. So, in the short recap I do tomorrow morning, or maybe early afternoon tomorrow, I'll go over that, but that pisses me off so much. And I know I've talked about it before, so I'm not gonna fall for it. The sexual harassment privilege protects Ms. Lively's allegedly defamatory statements, whether made in legal filings, to the media or to others. And that's a bunch of bullshit because she wasn't sexually harassed. Is the problem? Okay. Fuck you. Sorry, I'm reading through this. Under Section 47.1, a covered communication is defined as any factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication, including an act of sexual harassment by a director or producer, which would be valid if your director or producer harassed you, which they did not. An act of workplace harassment or discrimination, failure to prevent an act of workplace harassment or discrimination, aiding, abetting, and they bolded aiding, abetting for some reason, as if any of this actually happened, inciting, compelling, or coercing an act of workplace harassment or discrimination, or an act of retaliation against a person for reporting or opposing workplace harassment or discrimination. This is clearly not about the truth. It's about what you can spin to make it look like the truth. That's exactly what I'm getting from this filing. It's like, it doesn't matter if that's what they did, but these messages make it look like they were aiding and abetting. That's exactly what I'm getting from this. So, all right. To be protected by the sexual harassment privilege, the speaker need only have or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. Yikes. In other words, the sexual harassment privilege attaches regardless of whether a complaint is ever filed and no matter who the communication is published to, as explained by California's legislature. Well, congratulations, California. You've opened the door for a lot of shameful bullshit. And I like California, so that sucks. The protections would apply to individuals who, after relaying any factual statement, whether in the form of a formal complaint or a statement outside a formal proceeding, such as to a media outlet, are sued for defamation. Okay. Indeed, the statute was enacted in large part to address defamation claims filed against harassment victims based upon statements made to the press. Well, were they lying? That's kind of important. Because I'm not okay with just blindly punishing people for trying to file for defamation when somebody lies about them harassing. Oh my God, this is so annoying. Conclusion: after engaging in a retaliatory social media campaign against Miss Lively, plaintiffs now seek to drag her into a foreign courts. It's the state of Texas that you were just in, bitch. It's not like some rando place on Mars. A foreign court that lacks jurisdiction in an attempt to further punish her for privileged communications. Defaming a bunch of people to a large media outlet is not, or it should not be, privileged communications. But okay. All right. And these are her Texas lawyers. So Laura Lee Prather. Laura Lee Prather, you did your best. Thanks for that, I guess. Okay. Well, let's look at these other filings, shall we? I don't know if there's anything else we really need to look through tonight. If there is, obviously, we will do it. But we'll see. Why does it say 802 pages on the headline of the video? I really thought they did that many pages. They did. This is one of the 19 filings. One of the 19 documents they submitted to this filing. So, yeah. I put 802 pages in the headline because there are 802 pages. Jesus Christ. Anyways, moving on to the next filings. So let's go back to the table of contents here. So we just read, and I think that was, I want to say that was, these are the exhibits. So we just read 17-1. Hold on. Give me 1 second. Let me move my head real quick. All right. So we did this one, motion to dismiss. We looked through the exhibit list. Exhibit A, document 84, amended complaint. We don't need to look at that. Exhibit B, affidavit of Kelly Mursky. What is that? Let's look at Exhibit B here, number 4. Sorry, give me 1 second, guys. Oh, it's only 3 pages. We're good. In the 483rd Judicial District Court, County of Hayes, State of Texas, in re Blake Lively affidavit. Before me, the undersigned authority did personally appear Kelly Mursky, and being first duly sworn by me to testify to the following. She's a private process server, so this is just the process server stuff. We don't have to worry about that. So just saying basically that they were served. Hang on. I'll go back here real quick. Okay. Kelly Mursky process server. We got another process server. Articles of incorporation of street relations. Secretary of State of California. We'll look at that just in case. Hang on. What is that? 1, 2, 3, 4, 5, probably. Just make sure I'm pulling up the right document here. Affidavit in support of motion for substitute service. Okay, so I don't need that. Let's see, 17-6. Articles of incorporation with statement of conversion. We don't need that. 17-7. Certificate of conversion. We don't need that. Okay, I'm skipping over the stuff we don't need, and I'll post all of it in case you guys want to go through it. But for right now, I'm just going to skip over the stuff we don't need. This is Texas filing stuff. We're good there. Let's go to 17-9. Sorry, here. You can see that now. $17.10. Where's 10? There it is. Exhibit H. Jury trial demanded. What is this? Complaint. Okay, this is the amended complaint, I think. Let's go back to here. Let's go to 10. Complaint. Exhibit 1, Baldoni, California complaint. 12, Exhibit J. January 23rd. Emails from Brian Friedman. That's what I wanted to look at. Hang on. Here it is. All right, let me pull that up. Okay, so. And let me move my head again. Nope, that's not what I want. There it is. Okay. Exhibit J, these are emails. This is from Brian Friedman to Laura Prather, the attorney who filed this 802-page mess. Okay. I am unaware that we agreed to accept service. A lawyer is in the process of being retained who will reach out to you to discuss accepting service of process. Okay. For anything scheduled or related or time sensitive, we're not going to do that. Okay. Laura Prather, the attorney for Blake in Texas, responds, "Hi, Mr. Friedman, checking back on this. Has your office withdrawn its representation that it would accept service on behalf of Mr. Wallace? Please advise." He says, "I think we will, just waiting for Jad's lawyer." And Laura says, "Mr. Friedman, I was surprised by your email because your associate Tamar, I hope I'm saying that right, copied on this email is the person who reached out to the process server and indicated that your firm would accept service of process. We confirmed this again with the process server yesterday. The process server indicated that Tamar claims to have sent an email to me confirming this information, but to date, no such email has been received. Further, my associate Reed Pillifant, I hope I said that right, copied on this email, reached out to Tamar to confirm your acceptance of service and has received no response. Please let me know if you plan to no longer accept service on behalf of Mr. Wallace. Take care, Laura. God, look at this. This is so professional. Like, these people are just being professional lawyers talking back and forth to each other. Not like the way Gottlieb and Friedman are going back and forth with each other, which I love mess, don't get me wrong. But when Gottlieb responds on the press and stuff like that, it's like very aggressive. And this lady's just like, oh, okay, let me know, we'll just do our thing like we're supposed to. So Laura Lee Prather, thus far, is someone I have no problem with. Okay. To be clear, my office never agreed to accept service of process of anything. I have not spoken with you nor received anything from you until this email reserving all rights. Brian Friedman. Okay. Got it. Dear Mr. Friedman, I think we're reading it backwards is the problem. Dear Mr. Friedman, I hope this email finds you well. We were informed by your office that you represented Jed Wallace and agreed to accept service on his behalf. As a result, enclosed, please find the citation, the Rule 202 petition, and a Rule 11 letter for your execution accepting service. Okay. All right. So that's the end of that exhibit. Let's see what else we got. So that was the emails from Brian. What exhibit was that? Converting, we went through that, or we skipped over that. Original complaint Wayfarer Studios. Emails from Brian Friedman. Next is exhibit K, sorry, not A. Transcript of initial pretrial hearing, which I've already posted for you guys. If you can't find it, let me know in the comments below, and I will post it again for you as long as I see it. It takes me a little bit to respond to stuff sometimes. So, Exhibit L, petitioner's notice of non-suit without prejudice, February 4th. What was that? Let's check that out. So this was 1712, and we are a couple exhibits down. So it must be 1714. Yes, okay. Zoom in a little bit. Petitioner's notice of non-suit without prejudice. I think this is where she was asking to depose Jed, maybe? Yeah, I think it was. Pursuant to Texas Rule of Civil Procedure 162, Petitioner Blake Lively hereby voluntarily non-suits without prejudice her verified petition for Rule 202 deposition of Jed Wallace. Yeah, I've seen this before. Okay, so this was just asking for his depo. What else we got here? Let's see. Try this tab instead. Nope, wrong tab. Hold on one sec, guys. So we were on 1714. I'm going to go to 1715. Check that out. We're almost there, guys. I'm sorry. Declaration of Jed Wallace we read last week in a different suit. 1716. Exhibit N. Memorandum of Law in support of defendant Blake Lively. Oh my goodness. Oh boy, this is where it gets kind of crazy. I'll show it to you real quick. So here's Exhibit N. Give me one second. So this was the memorandum in support of defendant Blake Lively's motion to dismiss the amended complaint for related relief. And I think we read this. Oh, we did read this. It's not. So this is not the thing that I was thinking was going to be super complicated. Give me one second. Yeah, BLMTD privileged. Okay. I don't know if there's anything new in this, but if there is, I will let you guys know tomorrow morning when I go through the whole thing and skim through the important parts for you. That was 1716. Let me see what is 1717. Declaration. This is where I wanted to. This is where it gets complicated. Hang on, because this is nutty. Not nutty. Sorry. It's not this one. It's the thing that is attached to it. My name is Laura Lee Prather. I'm over 21 years of age and fully competent to testify about the matters contained herein. I'm a partner at Haynes and Boone's LLP and represent defendant Blake Lively in this case. I cannot talk anymore. The following statements are made within my personal knowledge and are true and correct. I submit this declaration, which is the complicated thing we're going to read, in support of Ms. Lively's motion to dismiss for lack of personal jurisdiction, proper venue, and failure to state a claim under federal rules of civil procedure 12B2, 12B3, and 12B6. Attached as Exhibit O-1 is a true and correct copy of the Legislative History Report and Analysis for Assembly Bill 933. Okay, so this was 1717. I'm going to 1718, which is where... Yep, this is definitely it. Okay, hang on. This is where it gets bulky and a little complicated. So, like I said, I'm going to post this for you guys because I'm not going through this whole thing. That would just be crazy. Oh, Omar, what's going on, man? Hey. 70-30 chance Lauren is not wearing pants. Hey, man, I'm wearing pajama bottoms right now, but it was more like 60-40, to be honest. But thanks for stopping by, dude. I'll send you these documents, by the way, Omar. It's 802 pages, but a lot of it's been seen before. So anyways, we're almost at the end here, guys, surprisingly. Exhibit O-1, legislative intent service, blah, 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 blah. Hang on. Okay. Declaration of Jenny. Who the hell's Jenny? Okay, it's one of the attorneys. Okay, so this is where they're going through that entire law, which is like something that Omar, my friend that I just mentioned, would be able to go over with you guys thoroughly and understand and explain things, because I am super not interested in going through 220 pages of legislative history. It is simply not going to happen. But I will post it for you guys, so anyone who's interested in reading it totally can. And Omar totally can. All right, so. High Court of Random Opinion. Love your stuff. Hi, Natalie. Thank you very much. I appreciate you. Okay. Oh, so we're not staying up till 6 a.m.? No, only until 2, I guess, equality. Because I'll probably get up at 6 and do a short version of this stuff for everyone else. But yeah. Gabrielle, good night. Thank you for swapping in. I appreciate it. All right. And all right, I'll totally send it to you as well. So good night. Oh, you go to bed, Omar? That's bullshit. All right. Haven't we all at this point done or been on a video and hid the fact that we weren't wearing pants? Me at work every weekday, dude. Because I only work in the ER on weekends now. So, okay. Let's go to the last one because I'm going to post this for you guys, but I'm not going to read it. Woo, that's way too much. Okay, 1719. This is the last one. I don't think it's really anything. The court, having considered defendant Blake Lively's unopposed motion to leave... Oh, yes, that's right. Okay. In excess of 20 pages, finds that motion is meritorious and should be granted. So this was an unopposed motion. So like Jad Wallace and his lawyers did not oppose this. They wanted to file a motion in excess of 20 pages, which I think it was like 40 something, that first motion that we read. So it was like the proposed motion, which is basically like the judge would just have to put his signature on it. The reason they didn't do that before is because they were supposed to file this whole document with that proposed motion. And so I had thought, I was like, oh, this is a lock, they're fine. But then it was like an error or something. So they had to, I guess, go through the whole thing again. And it got finally posted tonight just before midnight. So yeah. Anyways, thanks for sticking with me through all 19 of those documents that I skimmed. I'm going to put them all together now and post them on my page on X, on YouTube under the post tab, etc. So, all right. Thanks, everybody. I appreciate it. And I will talk to you tomorrow because it is already 1:40 a.m. and I'm exhausted. So, yeah. like I said, I appreciate it. I'll see you tomorrow. I'm also doing if you guys don't know what I'm talking about here, the reason I got started on YouTube was this case involving a lead of The Bachelor who was accused falsely of impregnating a woman with twins, and it turned out she has a whole conspiracy going on, and that case is still ongoing. She is going to try to take her fake pregnancy to the Supreme Court. So we're going to do a watch party of the lawyer for Laura Owens, the fake pregnancy lady, going against hot bench judge Rachel Juarez. So we'll see that. That'll be good this weekend. And then also tomorrow night, I don't know what I'm going to do because I'm going to watch the Final Four game between UF, my school, and Auburn, her school, tomorrow night. So I probably won't be streaming, but I'll see you Sunday night, if anything, and then I'll have that video out tomorrow morning. So thanks everyone for being here. Appreciate it. Thanks to Zach and Donna and Omar and everyone else who stopped by. I know I probably missed a lot of comments because I was busy reading through that bullshit, but appreciate it. And good night.